Yes, Mr. Carter.
Morning, my lords, thank you. I'll begin with an apology about the complete mess with the bundles last week, but I'm glad your lordships have got them. And having got that apology out of the way, I'll move on and get on with the appeal.
Well, we accept your apology.
Thank you.
And we've read I think all the salient documents. So we've read, obviously, the judgments, we've read the skeletons, and we've had a good look at the decision of this court in Williams.
Thank you.
But we think we're going to have to go through that quite carefully at a fairly early stage.
Yes.
No doubt I hope that was part of your plan.
It is, Your Honour. So I'm going to make my headline paragraph first, and then my first point is to talk about Williams, and then to move on to the. So perhaps I'll break it down.
So have you discussed with Mr. White how time is going to be divided and how long you think you're going to be?
We haven't. What Mr. White has done very helpfully is he has discovered another case called Dennis and Ministry of Defence, which is handed to me this morning. Now,
it's very generous of you, Mr.
Yes.
Mr. Carter. Usually that's regarded as not helpful.
Yes. Well, it was described by my learned friend as a mixed blessing. So we will see. But what I was going to propose is my submissions, obviously subject to how many questions your lordships have for me, in reality are going to take hour and a half.
Okay.
In terms of order, obviously I'm in your lordship's hands about whether, once I've dealt with my ground of appeal, whether you want me to deal with the respondents first, or I would suggest my learned friend respond to my points and then we deal with the respondents' grounds, but I'm in your lordship's hands on that. And then what I was going to ask is, given I've only seen the case of Dennis this morning, while my learned friend makes his submissions, I just have a bit of time to read that and just deal with some mopping up on any points that might raise, which I think is probably only going to take me 10 or 15 minutes.
I think I'd like to hear on everything. I think we'd like to do something slightly different.
Yes.
We'd like to hear you on everything, at all points, i.e. your appeal and the respondent's notice points.
Yes.
Then we'll rise so you can read Dennis.
Yes.
We can read Dennis.
Yes.
And then we'll come back and you can say what you want to say about Dennis, and then we'll hear from Mr. White.
I'm happy.
Is that all right?
Thank you, Mother.
Okay.
Yes. Thank
Right.
you.
Off you go then, Mr. Carter.
Well, I'll make my headline point first, and then I'll set out my submissions. My headline point is this, which is that in the Court of Appeal, Williams accepted that the presence of knotweed rhizomes in the soil constitute damage. And the claimant suffers a diminution in value of their property as a consequence of that damage. And His Honour Judge Beard, on the first appeal, who I will just refer to as the judge, got it right insofar as he accepted it was consequential loss, but he got it wrong when he said that it was pure economic loss. And so really my point is, if there is damage and consequential on that damage there is diminution in value, that is recoverable economic loss. So that's my headline point. And okay. Then in terms of my submissions, I'm going to take 3 points. The first is dealing with Williams, and why I say Williams is not authority that diminution in value is not recoverable. My second point then is to look at the judge's decision, which will not take very long, because really I say for my ground of appeal, paragraph 19 of the judge's decision is really the crux of the matter. And then my third point will be, regardless of whether your lordships are with me or against me on what Williams says, what the law should be. So those are really my 3 points. And I'll start with...
And then you'll come on to the respondent's notice point, which is causation and
yes.
the evidence.
Yes, indeed. Quite right. Apologies, my lord, for missing those out. I will. In terms of my first point then, about Williams, the Williams is not authority that diminution in value is irrecoverable, pure economic loss. And one can see why somebody reading Williams could take that view based on what the Court of Appeals said in Williams. But when looking at it in detail, it becomes clear that Williams was talking about whether or not whether encroachment without physical damage was capable of being a nuisance. So before I take your lordships to Williams, I will just take you to one other case very briefly first, which is the Delaware Mansions case. And in the authorities bundle, page 125,
So you've gone straight into the judgment.
yes. Would you? I can give your lordships a background if you would like. It was a tree roots case.
What's the point you want to make at 125?
Simply paragraph 31 with the green highlighting on the right, which is discussing Wagamam and Goldman and Hargrave, which are both nuisance cases. Yeah. But the point I rely on is starting on the third line of that paragraph about the label nuisance or negligence is treated as no real significance. In this field, I think the concern of the common law lies in working out the fair and just incidence of a neighbour's duty, rather than affixing a label and inferring the extent of the duty from it. But there is one difference I can see between negligence and nuisance, which leads into my point about Williams, which is in a nuisance case, before you come on to duty of care, breach of duty, causation, etc., you have to establish that there is actually something capable of amounting to a nuisance in the first place. And that is what was in issue in Williams. My lords, I won't rehearse what I've said in my skeleton, but what I will do is firstly take you to the first instance decision to explain or to demonstrate, I hope, what led up to or what was the context for the Court of Appeals decision in Williams. So in the authorities bundle, it starts at page 37, paragraph 43.
This is the recorder's decision.
This is the recorder's decision. But then it immediately goes on to page 38, but it begins at page 37, where he set out the issues. And issues 1A and B are really the context. So in that case, one of the issues, A, was whether encroachment was capable of amounting to a nuisance, and B was, if not, then does the presence of knotweed not within the boundaries of the claimant's property, but on the defendant's land, close to the boundaries, amount to a serious interference with quiet enjoyment. And the recorder found, and this is set out then in the authorities bundle at page 57,
page or para?
Page 57, my lord. And then paragraph 121. for completeness 119 as well, which I haven't marked, but he found it's obvious from reading the Court of Appeal decision in Williams, but he found against the claimant on encroachment, and I'll come on to the Court of Appeal in a moment, but he found against the claimants on encroachment, but paragraph 121, he found for the claimants on issue 1B, but his decision was there doesn't need to be encroachment at all. Having knotweed close to the boundary causes a depreciation in the value of the claimant's land, therefore that can amount to a nuisance. And my Lord, moving on, well, just before I move on to the Court of Appeal decision, since we're looking at the recorder's decision at the trial in Williams, it's perhaps helpful at this point just to touch on this in passing, is page 57 of the authorities bundle again, apologies, page 81, I'm sorry, of the authorities bundle.
Yes.
Paragraph 243 under the heading diminution of value of land. I won't read the whole paragraph. He awarded damages for residual diminution of value, so he awarded treatment costs and then the residual diminution of value, which is the stigma. And you can see the figures that he awarded for the two claimants in paragraphs 245 and 246. He allowed my Lord, I'm sorry, that's setting out the competing.
Yes.
I'm sorry,
that's
page
what the evidence
84.
was.
Page 84 of the authorities bundle is the actual findings that he made. Paragraph 261 for the first claimant, and then 263 for the second claimant. The figures were different, but he awarded them both treatment costs plus residual diminution in value. And then miscellaneous loss and general damages, but we don't need to worry about those. We then come on to Network Rail's appeal against that decision to the Court of Appeal. And, my Lords, if I can please take you to page 25 in the authorities bundle. This was Network Rail's second ground of appeal, which dealt with diminution in value. And I've marked in green the entirety of that page, and then it goes over the page.
Sorry, which page are you on?
25.
Oh, I missed it. 25.
So paragraph 76.
Yes. So Network Rail's second ground of appeal, which touched on diminution in value, was not the principle, it was the quantum. And Court of Appeal said, no, not going to remit to allow you to have a second bite of the cherry because that evidence should have been available at the trial. But the point is, Network Rail, when appealing, never raised the question of the recoverability of diminution in value, purely quantum. And I will turn in a minute to earlier on in the decision in Williams, particularly paragraph 46, etc., where it talks about the purpose of the tort of nuisance. But looking at paragraph 76, I would ask your lordships to consider, if you were making a decision and you found that, in principle, damages for diminution in value should not be recoverable because they were pure economic loss and the tort of nuisance was not designed to protect economic interests, surely that would be mentioned in paragraph 76 to say, well, this is OTOs in any event because in principle they are not recoverable damages. That is not said. And again, my lords, at the bottom of the same page 25, paragraph 82, saying that it would be wrong to remit the case to review the question of quantum. The final two lines of that page in paragraph 82, NR Network Rail cannot now have a second opportunity to depress the recoverable damages. But again, I'd ask your lordships to consider...
If they weren't recoverable at all at that point, it wouldn't have been expressed in that way. That's your
exactly, and this was a strong court of appeal with the master of the rolls.
We can agree with that submission.
Yes, thank you. Well, it would such a strong court of appeal have been so careless as to have phrased paragraph 76 and 82 in that way, if in fact their decision was that in principle diminution in value was not recoverable? I say no, that is absurd. So I then come on to dealing with why I say that I do understand when reading Williams why somebody can read it and at face value think it does say what the respondent and the judge says it says. So I'll come on to that now. But that is the context, that actually paragraphs 76 and 82, it is quite clear that the Court of Appeal certainly would have made a very surprising omission in not mentioning that point in those paragraphs, if that was in fact their decision. And that is a point I made before the judge below, and as I've addressed in my skeleton, this is no criticism of him, but he just hasn't dealt with that.
Didn't mention
at all.
that.
Exactly. And he was wrong not to deal with that. And there isn't an answer to that other than a strong Court of Appeal made a very serious mistake, and that's a surprising conclusion to reach. And so the starting point, I say, is Williams. That is a strong point that militates in favour that Williams is not authority, that diminution in value is not recoverable. And then finally, having taken your lordships to the recorder's decision at the trial, where he awarded damages to both claimants for diminution in value, both claimants were still entitled to those damages following the Court of Appeal's decision. The Court of Appeal did not make them repay any of the damages for diminution in value to Network Rail. So again, same point, would such a strong Court of Appeal have made such a serious error? And Network Rail were led by leading counsel, who again one would have thought, certainly in terms of the consequential order from the Court of Appeal's decision, wouldn't have agreed to an order where the claimants were still entitled to their damages for diminution in value. So the context of all of this is that the principle of the recoverability of diminution in value was just never an issue. The discussion about the purpose of the tort of nuisance and about economic interests was purely in relation to what I have called, what I can see as the one distinction, despite what Delaware says, between nuisance and negligence, which is in a nuisance case, you've got that additional step to begin with of, is there actually something capable of amounting to a nuisance before you come on to questions of duty breach, etc. And it was on that question of, is there something that's capable of amounting to a nuisance, that was an issue in Williams. My lords, can I take you then, please, in the authorities bundle to page 15. And it's paragraph 41 from the Master of the Rolls' judgment, where he quotes Lord Lloyd in Hunter and Canary Wharf. And
the three kinds of nuisance.
Exactly. And I've acknowledged in my skeleton, and I acknowledge now, the Court of Appeal says it's not helpful to rigidly categorise.
Yeah, well, the passage immediately after that citation
Exactly.
is
So I acknowledge that point, and as a general proposition, I take no issue with that. But I am going to rigidly categorise it because it does again put into context the decision in Williams. So looking at the quote from Lord Lloyd in Hunter and Canary Wharf, at trial, the issues effectively were the claimants were seeking a type 1 nuisance, nuisance by encroachment, and a type 3 nuisance, which was interference with quiet enjoyment. They accepted there was no physical damage, and so they never claimed a type 2 nuisance.
yeah.
And again, I accept the point made in paragraph 41 about the difficulty with rigid categorisation, but in effect, what the Court of Appeal did in Williams, well, what the recorder did was to find there is no type 1 nuisance because that does actually require damage, and he found there was no damage. But the recorder found there was a type 3 nuisance because there was knotweed on the defendant's land close to the claimant's. That affected the value of the claimant's land, and therefore that amounted to an interference with the claimant's quiet enjoyment. And the Court of Appeal's decision in Williams upheld the recorder's ultimate decision, finding for the claimant, but effectively took the opposite approach.
There was a type. There was type 1, but wasn't type 3.
Exactly. And so all of the discussion, for example, on page 17 in the authorities bundle, under the heading Appeal Ground 1, all of the discussion, particularly paragraph 46, and I acknowledge reading it at face value, I can see why anybody might think that Williams says you can't recover damages. But for example, paragraph 46, the recorder's conclusion, presence of knotweed on network rails land within 7 metres was an actionable nuisance simply because it diminished the market value of claimants' respective properties because of lender court in such situations was wrong in principle. And then there is discussion in paragraph 48 about the purpose of the tort of nuisance is not to protect the value of property as an investment or a financial asset. But all of this was under Network Rail's Appeal Ground 1, which went to whether or not there was something capable of being a nuisance, and it went to effectively the type 3 nuisance under Hunter. So, my lords, I say that when you take those points together, the paragraph 76 and paragraph 82 describing diminution as recoverable damages, the fact the claimants were not required to repay the damages they'd been awarded at trial for diminution in value, and the context of Williams, which went to whether there was actually something capable of amounting to a nuisance, it becomes clear, I say at that point, that Williams is not authority, that diminution in value in a nuisance case such as this is pure economic loss.
Are we going to look at what the Master Roll said at paragraph 52 onwards?
Yes, my lord, yes. It starts page 19. There is overlap because so that's the claimant's grounds 1 and 2. I'm sure your lordships will have appreciated this. So Network Rail appealed under ground 1, which started at paragraph 46. The claimants filed a respondent's notice, and then this deals with those headings. But effectively, there was overlap. And Network Rail said recorder was wrong to find a type 3 nuisance, and the claimant said recorder was wrong not to find a type 1 nuisance. But again, my lord, nothing in paragraphs 52 onwards changes that fact. And I appreciate your lordship said a careful reading of Williams is likely to be important. And I'm conscious of that, and I don't want to at any stage seem flippant by skipping over any relevant details. But really, I say actually, the wording does not, the careful reading of the wording in Williams does not assist your lordships in the way you might think, because it is about the context of how and why Williams was decided. And so to answer your lordship's point, or at least pointer towards paragraph 52 onwards, my point is the same as I had made for paragraph 46 onwards, which is, again, all of this went to the question of, can the presence of rhizomes in the soil which have not actually caused physical damage amount to a actionable nuisance, at which point questions of duty breach, etc. kick in. And in particular, my lord, paragraph 54, which is over the page on 20, where the Master of the Rolls disagreed with the recorder, and then at paragraph 55 talked about knotweed rightly being described as a pernicious weed. It does not only carry the risk of future physical damage structures and to building structures and installations, its presence, and indeed the mere presence of its rhizomes, imposes an immediate burden on the owner of the land in terms of an increased difficulty in the ability to develop, etc. At the end, the final sentence, or the final two sentences, about they affect the owner's ability fully to use and enjoy the land. They are classic examples of an interference with the amenity value of land. So for there to be a nuisance, there must be well, again, acknowledging the point about avoiding rigid categorizations, effectively that head, and I mean no, I apologise for effectively ignoring repeatedly what the Court of Appeal says about avoiding rigid categorizations, but I do say it's helpful to understand the context of the decision. That is saying, particularly in paragraph 55, that effectively there is a type 1 nuisance. And paragraph 56 summarises the recorder's findings. Network Rail had come under a duty because they had actual knowledge from 2013. They were in breach, etc. And then the final three lines of that paragraph 56, if and insofar as damage is required to complete that cause of action, it is constituted by the diminished ability of the claimants to use and enjoy the amenity of their properties. So on the Hunter type 1 nuisance of encroachment, the Master of the Rolls said, well, if damage is required, then it is met by the presence of the rhizomes and the effect that has on the amenity and the ability of the claimants to use their land.
This is the presence of the rhizomes on the claimant's land?
Yes. So at trial, one of the issues at trial was whether knotweed had even encroached at all, because in Williams and Wastel there were two bungalows and the boundary was a wall which ran right up against the land. So it wasn't like a garden where knotweed was visible in the garden, and there was a question, dispute of fact, about whether rhizomes had actually encroached at all. The recorder found that they did, but because he found that physical damage was a necessary requirement for a type 1 nuisance, he found that the claimants could not establish an actionable nuisance on that basis. He did find the type 3 nuisance, and the Court of Appeal, as I say, effectively reversed that and did find, if one did use the rigid categorizations, a type 1 nuisance based on the pernicious nature and effects of knotweed.
When reading the Master Rolls summary of the findings,
yes,
in paragraph 56, the recorder's finding 56, we should actually read a further finding, shouldn't we? That the knotweed had encroached from the defendants onto the claimant's land.
Yes.
That was a fact. That was.
Yes.
That seems to me, for my part, to be a part of the stepping stone in the Court of Appeals.
It is.
It's the beginning of 53.
Yes.
Beginning of paragraph 53, the recorder found that Japanese knotweed rhizomes have encroached on the land of each of the claimants under their respective bungalows.
He did. Thank you. Yes.
That's right.
So it was an issue at trial. Defendants denied, or at least put claimants to proof, and the recorder found that knotweed had in fact encroached. The claimants then argued at trial, because there is encroachment, that amounts to an actionable nuisance. The recorder said no, because you also need physical damage. That's the type 1 nuisance argument. And the Court of Appeal said there had been a finding of encroachment, and the presence of rhizomes in the soil was in itself enough to constitute a nuisance.
Well, it's as my lord points out, it's the finding recorded at the first page of 53, first line of 53, yes. Then the findings in 1, 2, 3, 56, and then the last sentence of 56. Yeah.
Yes.
That's what it is, as I see it.
The curiosity in 56 is that it doesn't mention the thing which at least seems to have been crucial in 53 all the way to 55, which is that it's loss of immunity, which is the consequence of the presence of the knotweed on the claimant's land. That's what's unspoken, the unspoken
encroachment onto the claimant's land.
Because 56 is talking about presence of the knotweed on the defendant's land all the time.
Yes.
But what the Court of Appeal are doing is, so when it says, when the Master Rolls there says that is sufficient, we have to understand that what is sufficient is that reasoning, but all in a context in which there's encroachment. Yes,
and for the avoidance of doubt, in this case there was encroachment, and that was found as a fact at trial, and it was found it had encroached before the defendant came under a duty of care, which comes on to the causation point that I'll deal with, which is one of the respondent's grounds. But yes, Williams' authority for this, Williams' authority that there must be encroachment, but if there is encroachment of rhizomes, that is sufficient to cause a nuisance without the need for physical damage. And that is, as I say, looking at Delaware and thinking about the similarities or differences between nuisance and negligence. Nuisance requires that initial step of, well, is there actually something capable of being a nuisance in the first place before you even come onto duty, etc.
So, if my neighbour has knotweed on their land,
yes,
and it doesn't come across the fence,
yes,
it just stays on their land and they do nothing about it, they like it, looks good to them, fine. I have no cause of action in negligence, in nuisance,
or negligence,
because nothing has come across the fence.
Yes.
There is no encroachment, and
yes.
I cannot say people will pay me less for my house because they know there's a risk
yes.
that something will eventually come across the fence.
Yes.
That's not nuisance.
No, exactly.
So in a sense, that Williams' authority for that negative proposition.
Exactly.
But as soon as somebody lets knotweed come across the fence,
yes,
such that there are rhizomes in the claimant soil, my soil,
yes,
game on.
Exactly.
I've got a claim in nuisance.
Exactly.
Not because my soil has been damaged, although somebody might say actually it's poorer quality soil, it actually has to be removed.
Yes.
That's not the way it's analysed. It's analysed because of the encroachment itself and the loss of my ability to enjoy the land because there are rhizomes in the soil.
Yes. So if your neighbour, exactly, if your neighbour has knotweed on his or her land and that diminishes the value of your property, but it hasn't, the rhizomes haven't come onto the ground, you've got no cause of action. As soon as it encroaches, you have a cause of action. That's what Williams is authority for.
So, and if I step back a little bit further in terms of nuisance, if my neighbour does something on his land, which he's lawfully entitled to do, but which others who might buy my property might find undesirable,
Yes.
that I don't have a cause of action in nuisance simply because my property is worth less because I'm next to him. I mean, that was the sex shop.
Yes, it was. Yes, that's what I was thinking, my lord. I agree with you on that. No issue about that at all.
But as soon as something comes across the boundary, whether it's Japanese knotweed or noise or smoke or anything else from a breach of a duty from my neighbour's land,
well,
there's a cause of action in nuisance.
Not necessarily anything, but Williams's authority that knotweed certainly once it comes across. So, for example, in a tree roots case, if there is a tree and the roots grow under the soil under your land, and you do not have a cause of action unless it causes cracking. So, thinking of a classic subsidence damage case, cracking due to the presence of tree roots causing subsidence. But the Court of Appeal in Williams said that because of the pernicious nature of knotweed, its mere presence in the soil amounts to damage, in inverted commas, damage being an elastic concept. So,
and that's paragraph 55. That's why it's characterised in that paragraph as a natural hazard.
Yes,
that's what's going on in that paragraph. And that's a distinction from a tree root, which is only a hazard if it's doing something specifically bad. But tree roots per se are not natural hazards.
Yes.
But you can claim, as I understand it, you can claim damages for nuisance without physical damage if there is some emanation from your neighbour's land onto yours which reduces the amenity value of your land, such as noise, smoke, smell, dust, or other emanation. I'm just looking at paragraph 43.
Yes. Yes, my lord, I agree. But really, the crucial point, the only reason I hesitate is I agree with that, but there may be certain cases where it might not amount to, but certainly Williams's authority, positive authority, or authority for the positive proposition that the presence of rhizomes once they encroach constitute.
Yes.
So
what my lord is pointing out is it's nuisance through interference with the amenity in the land. So not all encroachments, roots being,
yes.
Roots go under walls all the time.
Yeah, yes.
And they don't interfere with the amenity of the claimant's land in every case. In most cases they don't.
No, they don't. I take that
But
point.
smoke, etc., as my lord points out, they do. Of course, damages isn't the only remedy, but
yes,
which would arise in these cases.
Yes, so I agree with that proposition.
So encroachment plus loss of amenity. I mean, this is why they perhaps warn against rigid categorization.
Yes.
But certainly if you have a encroachment coupled with a loss of amenity of the type in relation to Japanese knotweed mentioned in paragraph 55, in other words, if Japanese knotweed is encroached onto my land, and I've got to go through a process there, digging my land out,
yes.
taking up the flower beds, bringing somebody in to cart away in a safe fashion tons of soil,
yes.
replacing the soil, and then waiting, hoping against hope that it doesn't come back because they've got everything out.
Yes.
So I perhaps can't plant expensive flowers in my flower bed because it'll just come back.
Yeah.
That's apparently affecting my ability fully to use and enjoy my land. That's a classic interference with the amenity value of land. So encroachment plus disruption of
exactly.
that type equals
yes.
recoverable
That
loss
then,
in nuisance.
Yes.
By reference, you say, to the diminution in value of land.
Well, it's the per Williams. There is in principle an actionable nuisance once there is encroachment of knotweed rhizomes because they interfere with the amenity value of the land.
Even when removed.
Even
when a process of removal has gone through, the risk is you may not have got them all.
Well, that really then brings me on to a different point to answer your lordship's question, which is that's what I say Williams is authority for, is purely for that first point. And your lordship's question then about diminution in value, I say it is not authority for that, and I've addressed you on that about why that was never actually an issue, why it would have been mentioned in 76 and 82 if it was an issue. But effectively, Williams is authority that encroachment plus amenity constitutes an actionable nuisance. Is in principle capable of constituting an actionable nuisance, at which point you get into the territory of duty, breach, etc. Williams then, on the question of diminution in value, this comes on really to my second point about the judge's decision.
Yes, do you want to go to look at that then?
In the core bundle, at page 57, is that using the number in the bottom right? I think. My lords, because of the horrendous mess with the bundle, I had fixed it and saved it and put new pagination in the bottom right of every page, which I flagged up to your
Thank
clerk.
you. Well, should we deal with would it be easy to deal with paragraph numbers because
Yes,
we were working off the other versions, at least I was.
Yes, well, it's paragraph 19 of the judgment.
Okay, so that is 57 of this latest version.
It's 57 in the bottom right.
Yes.
It's got a 55 at the top.
Oh, I see.
Paragraph.
So yeah, let's go with it. Let's
Judge
go.
Beard's judgment.
Yes.
19. Right.
And the relief in terms of bundles is that actually, really, paragraph 19 is, I say, the crux and the only real paragraph of real relevance to my point about the judge's decision. So the judge, my argument, well, really, the judge's acceptance of my argument, but then his decision is set out in the final 3 lines. Well, I won't try and confine it to that, so I'll let your lordships read the paragraph in full.
Yes, and that phrase in Williams, remind us, you've taken us to it already, I think. Where is that precisely in the judgment of Williams?
Thank you. It's paragraph 48, my lord, which is page 17 of the authorities bundle.
And that, of course, is a development of the point made in paragraph 46.
Yes. So paragraphs 46 and 48, taken at face value, are, on the face of it, I accept, seem to say diminution in value should not be recoverable. But actually, when looked at in detail, I say that's not what they were saying, because they were dealing with the principle of whether there is actually an actionable nuisance in the first place. The judge's decision then, at paragraph 19, is I say he got it partly right and partly wrong. And of course, I say the part he got partly right is the part where he agreed with me, and then where he disagreed, I say he got it partly wrong. But my point is this. Williams says that once there is encroachment of knotweed, there is in principle an actionable nuisance. And if damage is required for that cause of action, there is damage. And that is found paragraph 42 in the Court of Appeal's decision in Williams, which starts at page 15 in the authoritative bundle, excuse me, but then goes on to page 16, and the relevant parts at 16D. Talking about historic cases, and then the final 3 lines saying that that in itself shows both the artificiality and elasticity of any requirement of damage for the purpose of establishing nuisance. And there is also the same or a similar reference to damage being elastic in Williams at page 22 of the authorities bundle, at paragraph 64.
I mean, sorry, you're not. Is 43 not relevant to this? I mean, why stop at 42?
Well, my lord, the reason I stop at 42, 43 is relevant in that it says physical damage is not necessary to complete the cause of action.
Yeah.
But 42 says in any event damage is an elastic concept, and at page 22 of the authorities bundle, paragraph 64.
Oh, sorry, I mean, I was looking at just above G.
G on page 22, my lord. Sorry,
No,
still on paragraph 43.
Okay.
What the Master Roll said is, what is relevant is the objective effect on the immunity value of the land itself, and it is that effect which satisfies any requirement there may be to show damage.
Yes.
So, as I understood him in this paragraph, where he was referring to third category cases, a fortiori where you've actually got an encroachment case, which I think these are sort of all coupled with encroachment, because he talks about noise, smoke, smell, dust, or other emanations. If you've got an emanation coming across from your neighbour's land, and that reduces the amenity value of your land, your ability to use it, then if there is a requirement to show damage, that's satisfied. That's what he appears to be saying there.
Well, I agree with that, but then 43 is then almost 43 falls under the heading of general principles in italics at the top of page 15, and then really the point that's made in 43 is again made in conclusion when dealing with appeal ground 1 under the heading starting on page 17, and in particular paragraph 47 that I've taken your lordships to about the objective loss of immunity. So I certainly don't disagree that paragraph 43 isn't relevant.
And the curiosity is that loss of immunity, as I understand what the Master Rules is saying in the judgment as a whole, you can have an impact on loss of immunity which causes diminution in value, which isn't actionable.
Yes.
That's the ground 1 because all that's happened, because it's only an impact on the amenity value of your land caused by what your neighbour has done, but is only staying, it's the knotweed in the defendant's garden. That isn't a nuisance, but you can have a loss of amenity, you say, which can include consequences like diminution in value. If it's caused by something which is on your own land, some emanation that's come out of your defendant's land into your land, then it is actionable. That's the point.
Yes, and that was all dealt with in Williams, but where the judge has gone wrong, I say, and where the respondent is wrong, is to take Williams a step further to say that Williams is authority for the proposition that one cannot recover damages for diminution in value because they're pure economic loss. So I don't disagree with any of that, but that Williams was purely focused on the principle of, is there an actionable nuisance by virtue of knotweed, to which the Court of Appeal said, yes, if there is encroachment because the rhizomes interfere with the amenity of the land. And on the diminution question, Network Rail never took issue with the principle, purely the quantum, and the strong Court of Appeal, again, made reference in 76 and 82 to diminution in value without doing what would have been the most obvious thing in the world, which is to say, well, actually, we find that it's not recoverable because the tort of nuisance does not serve to protect economic interests. So I don't disagree with any of that, but really where I say the judge has gone wrong is to take Williams too far and to take his authority for something that it isn't authority for, which is that one cannot recover damages for diminution of value because they're pure economic loss.
The problem may be in the categorization. This simple three category analysis, it may actually, with the benefit of more examination over the subsequent years since Hunter, it may actually be unhelpful to have that as a straightforward, simple categorization. I don't know.
Yes. Well, as I say, I've noted that the Master of the Rolls made that comment, and I've acknowledged that I'm effectively ignoring that comment, but I'm ignoring it because it explains the context of what led up to the decision in Williams and how the Court of Appeal approached it. And the reality is, if you look at Hunter and Canary Wharf, the Court of Appeal in Williams did effectively say there is a Type 1 nuisance, but there isn't a Type 3 nuisance. That is the effect, if you did follow that rigid categorisation of what the Court of Appeal did.
I mean that sentence that the judge was referring to appears in paragraph 48, doesn't it?
Yeah.
And 48 is against the background of the finding that the recorder had reached, or sorry, the issue with which the recorder was then grappling, which is that he was dealing with the question of whether the pure presence of knotweed on the defendant's land was an actionable nuisance simply because it diminished the market value of the neighbouring property.
Yes.
And the Master Rolls said that's wrong.
Yes.
Because if you look at both the first two sentences of paragraph 48, if all that's happened is that your neighbour has rhizomes on their land, your use of your land, your enjoyment of your land, is not in any way affected.
Yes. Yes.
A nervous purchaser might pay you less for it because of what might happen in the future, but nothing has yet happened to your land,
Indeed.
to your enjoyment of your land. You don't have to do anything, you can just sit there and be rhizome free.
Yes.
But that all changes when the rhizomes come across the fence.
It does, and that's
so you have to put that into into context, I think, is what.
Well, yes, Williams is authority for that point that your Lordship has just summarised, that there must be encroachment. But paragraphs 46 and 48, looking at 48 because your Lordship had referred to that specifically, about the purpose of the tort of nuisance is not to protect the value of the property as an investment or financial asset. That was all in the context of the appeal ground won by Network Rail, which is there is nothing in principle capable of amounting to a nuisance.
Yeah.
The Type 3, effectively Network Rail said there is no Type 3 nuisance. So all of the discussion about the purpose of the tort of nuisance protecting the value, not being designed to protect the value of property as an investment or financial asset, that goes to that question of type 3 nuisance, the appeal ground 1. But all of that is under the umbrella of, is there actually, in principle, an actionable nuisance in the first place before we get on to duty, breach, etc.?
Really, the quote from 48 it arguably should not just stop at the end of the first sentence, but should include the second.
Yes.
And perhaps one should insert the word simply after not in the first sentence. Because this is on your case. On your case,
yes,
where there is an interference with the use and enjoyment of the land, then economic loss is recoverable. That's your point, isn't it? Or maybe recoverable.
Yes, and indeed the word simply is used in paragraph 46, but I would agree, and on my case is that, yes, effectively it should also be inserted into paragraph, the word simply should also be inserted into paragraph 48.
And if we go to what how the judge used the phrase in 19.
Yes, so
he says it couldn't, that the first sentence of 48 couldn't be clearer.
Yes.
Your case is, well, taken out of context.
Exactly. And as I started this appeal, I fully accept how somebody reading Williams can read that and on the face of it say, well, this is clearly authority that diminution of value is not recoverable. But actually, on a close analysis, it does emerge that it isn't authority for that, for the reasons I've said.
Okay. So that probably deals with paragraph 19 of the judgment. Is there anything else in the judgment you want to refer to?
Paragraph 19, really, my point is this, which is that at the end of that paragraph in 19, the judge has accepted Mr. Carter's argument that this is damage leading to a loss which is consequential on the nuisance found. However, it's not recoverable damage; it's pure economic loss. So my point is this, which is, again, going back to Delaware and about the difficulty or the lack of a real distinction between nuisance and negligence. And as I say, there is perhaps one difference, which is in a nuisance case, you've got to actually establish there is something capable of amounting to a nuisance, which was what Williams was about. But my point is, there is encroachment, which amounts in principle to a nuisance, and on the authority of Williams, it is damage. And the judge in paragraph 19 accepted that it is damage, but the question really, and it's that I would say it's ultimately the crucial question on my ground of appeal, is the diminution in value, I say, is recoverable because it is consequential economic loss rather than pure economic loss. And it is consequential on damage.
Yes.
And the judge says in paragraph 19, well, there may be damage, but it's not physical damage. Well, firstly, thinking about the facts, it is physical in that there is physically, literally rhizomes in the soil, so it's difficult to see how there isn't physical damage. But my second point well, apologies, that really, I'm going to pause because that's going to lead into my third point.
Okay. Well, have we, I get the sense we probably covered this particular point.
Yes. Your lordships have my point on that.
I think we do.
So it's consequential loss, and the final point I would make, apologise, because there was one reference that I wanted to take your lordships to, which is in the authorities bundle at page 22. And it's from Williams again. And it's paragraph 64, where he quoted from Lord Justice Sheeman at paragraph 77, and it was from the Jan Denol case. You can see that from the foregoing paragraph 63. But in paragraph 64, before quoting, he says, again, consistently with the elastic concept of damage in this area. So that was the only 42 and 64 in Williams, both talk about the elasticity of damage. So that brings me on to my third point then, which is, having said firstly that Williams is authority purely on the question of whether there is an actionable nuisance in the first place, and then touching on the judge's judgment, my third point then is this, which is Williams accepts that damage is an elastic concept, and there is damage, and it is physical damage because there are rhizomes physically in the soil, but in any event there is damage, and if consequential on that damage the claimant suffers loss, then that is recoverable consequential loss. It is not irrecoverable pure economic loss.
I won't go over old ground. I'm not sure you're right about the physical damage bit, but in any event, the point is the loss of amenity by the presence of rhizomes is, I think you say, enough.
Yes,
to constitute damage within the meaning of the tort.
Yes, exactly.
Right.
So Williams talks about the elasticity of damage in paragraphs 42 and 64.
In other words, more than physical damage.
Yes.
Right.
Well, there is damage, and consequential on that damage, the claimant suffers a diminution in value of his property, and that ought to be recoverable. And in that respect, the judge, again in paragraph 19, again, not going over old ground, but he mentions an article, The Gist of Negligence, which my learned friend and I had agreed that your lawyer...
Professor Stapleton.
Yes. Had found the article. It's from 1988 rather than the early 1990s. We took the view your lordships would not particularly appreciate reading a historic academic article about it, because we can make the point really without reference to that article. But if one steps back, thinks about Delaware and what Delaware says about there's no real distinction between negligence and nuisance, they're labels, and then think about the flexibility of the law of nuisance and the way the law of negligence, and the way the law of negligence is developed in terms of recognising psychiatric injury, in terms of primary victims, secondary victims, with the Alcott case after the Hillsborough disaster, Headley Byrne, negligent misstatement, the way that the law of negligence has developed, and the law of nuisance, if one takes the approach that the judge did, then effectively it does create an artificial, well, no, I'll put it this way, apologies. The law of negligence, as I say, for all of those examples, is clearly flexible. And I would take you specifically in the context of nuisance, my lords, to, in the authorities bundle, page 109. And this is from the Court of Appeal decision in Jalla, decision of Lord Justice Coulson. Jalla referenced Williams. The issue in Jalla is an oil spill off the coast of Nigeria, and it's a question about limitation and whether there was a continuing nuisance, so the clock continued to run. So it's not directly on point. But paragraph 79 is directly on point, which is where Lord Justice Coulson says in paragraph 79 he accepts the modern law of nuisance is flexible. And so my point is this: if there is damage, which Williams accepts that the presence of rhizomes constitutes, and a claimant suffers a diminution in value of his or her land as a consequence of that damage, then if you are against me on my previous points, then the law ought to be flexible enough to recognise that a claimant should be able to recover damages for diminution in value of their property.
Hang on, the damage, as I understand it, is not the presence of rhizomes on the land. The damage that the Master Rolls was talking about is the diminished ability of the claimants to use and enjoy their property as a result of rhizomes on the land.
Encroachment plus.
In other words,
Yes.
the mere presence of rhizomes on the land does, I thought, certainly looking at the decision of the recorder, which in this sense, which the Master Rolls didn't agree,
Yes.
didn't disagree with, sorry, was that the mere presence of rhizomes on the land is not physical damage, it's a presence. But as I understood it from 55 and 56, the damage, if damage is required to complete the cause of action, is constituted by the diminished ability of the claimants to use and enjoy the amenity of their properties.
Yes.
Right.
That's a feature of knotweed, or that was the evidence. That was a feature. It was.
Yes.
That would follow. Where that's your point. The distinction with tree roots. But it is the loss of amenity.
The damage is the loss of amenity. Now, is loss of amenity different from a diminution in value of land? How do the two relate?
Well,
I mean,
that was effectively what the judge held and what the respondent argued, which is to say there's a loss of amenity, but that is different to a diminution in value, and that diminution in value is irrecoverable pure economic loss. So that is really the respondent's case and what the judge found, that there is a difference.
right. But, okay, but I'm not talking about whether the result is different. I'm just talking now about loss of a figure for loss of amenity, what compensates you for your inability to do something on the land, enjoy it to the full.
Yes.
And is that different, or is that related in some way to the fact that somebody will pay you less for your land because they won't be able to enjoy the land to the full?
Well,
What's the connection
they are
between the two?
The connection is that the diminution in value is consequential on the loss of amenity. The diminution in value, there is paragraph 55 and 56 in Williams, as your lordship has pointed out, particularly paragraph 56, about it's the diminished ability of the claimants to use and enjoy the amenity of their properties. But then, if you think, again, taking your lordship's example of your neighbour has knotweed on their land that doesn't encroach, you've got no cause of action, but then it encroaches, and you do, because you've then got rhizomes in your soil, which affect what you can do, and also, even if it is treated, there is then a stigma, which is the residual diminution in value, which is why in the first decision in Williams, the recorder awarded the cost of treatment plus residual diminution in value. So there is an interference with your ability to use and enjoy, or an interference with the amenity value of your property. If then, as a consequence of that, you want to sell your house, for example, and your house is worth less as a consequence of the presence of the knotweed, that is an economic loss, but it is a consequential economic loss rather than a pure economic loss which is irrecoverable. Does that point make...
Sorry. You...
No, well, I was about to ask, does that point make sense?
Okay, well, I think, as I understand it, this expression, economic loss, I mean, it's one of those, takes you back to university law essay days. It doesn't really mean economic loss. It means, as used in this case, and in some others, but just to focus on this case for a second, because para 64, as you pointed out, expressly contemplates that damage to the economic interests of the claimant is recoverable. So the fact that loss could be called economic isn't a reason why it's not loss that's recoverable. What people mean when they say economic loss is a loss which has not had the right kind of cause.
Yes, and that's
the distinction between the two cases in Williams.
Yes.
Because in the first case, it's called economic loss as irrecoverable because it's accepted for the purpose of the argument that it's true that the claimant's property's value has dropped as a result of the presence of the knotweed on the defendant's land.
Yes.
But that is called, we call it pure economic loss because nothing else other than the happenstance that it's on the defendant's land has caused that loss.
Yes.
And that's why it's irrecoverable. And putting it another way, the fact that it's true that the defendant in this example can be said to have caused a diminution in value, they haven't, and this is what the Court of Appeals say, caused an effect on amenity value. The diminution which they have caused by the presence of knotweed on their own land has caused a diminution in value, but that's not to be regarded as causing an amenity, a damage to the amenity value, because they haven't done anything to the claimant's land. They've only done something on their own land.
Yes.
And that's why that claim was wrong, because diminution in value doesn't count as harm to amenity.
Yes.
Whereas the other way round, once you've found knotweed on the claimant's land, that para 55 is an immediate burden because it's a hazard. And that is, if you want damage, damage. And then you say you get all the consequences of that, which are including the economic consequences, see para 64, and that's your diminution in value.
It is actually, my lord, I agree. And that's where the Court of Appeal in Williams found the recorder went wrong in terms of the type 3 nuisance of interference, when the recorder said the presence of knotweed on the defendant's land interferes with the claimant's quiet enjoyment because it affects the value. Effectively, the Court of Appeal found the recorder had put the cart before the horse, and before you've got to establish duty, breach, etc., before you then look at what losses flow from that. But the recorder had done it the wrong way round and looked at the damage and said the damage itself amounts to the cause of action, and so put the cart before the horse. And that's why the Court of Appeal found what it did and found the recorder was wrong, but found that there effectively the type 1 nuisance, encroachment plus damage
So can I try and simplify this a little bit? My neighbour's got knotweed.
Yes.
It stays on his land. He keeps it cut. It goes nowhere near the fence. It doesn't come over to me.
Yes.
I have, even though I might be able to only sell my property for less because somebody coming in will look at my neighbour and think, goodness me, that might change. I'm not going to pay as much. That is not the tort of nuisance, and I cannot recover the diminution in value of my property as a consequence. That's a simple proposition derived from Williams.
Yes.
Second proposition is that the knotweed comes across to my land in breach of a duty that my neighbour had, having been told about it, did nothing, came across the fence onto my land. That's an actionable nuisance because there is encroachment resulting in presence of rhizomes and a loss of amenity, because knowing that they're on my land, I've got to do something about it to get rid of it,
Yes.
which means my garden's out of action for a while.
Yes.
I can't use my garden. I can't, plant my favourite plants where I want to for a while.
Yes.
So I lose the enjoyment of my land. So I can recover both the costs of removal, yes,
Yes.
and a sum to compensate me for the fact I can't put my favourite plants where the knotweed was.
Yes.
Certainly whilst the knotweed's being removed anyway. Yeah?
Yes.
That's loss of amenity. It's the loss of enjoyment.
Yes.
Right. Suppose I think, I want to move to France.
Yes.
Actually, I'm sick of this.
Yes.
Sick of the weather. Sick of the knotweed.
Okay.
Like home in France.
Okay.
Carry on.
So my loss of amenity of this property is actually limited because I'm moving. But the value of the property when I resell it, when I want to sell it, will be less because the purchaser coming in will also think, well, I can't use that flower bed, etc., etc., etc.
Yes.
That's economic loss in the sense it's not loss of my amenity, it's loss of my ability to sell the land for the price I would otherwise have been able to.
Yes.
You say that's consequential upon the first heads of recoverable loss or damage and recoverable loss. So I should be able to recover it even though it's got nothing to do with my enjoyment of my land.
No, there is reference, and I would have to check where this reference is, but there is reference certainly in Williams to the nature of nuisance and it attaching to the property rather than the individual.
Yes.
So in your lordship's example, yes, if you decide to move to France and you go to sell, although your own loss of amenity no longer continues, the property remains blighted, and therefore, as a consequence of the blight due to the knotweed, there is an economic loss, and it is a recoverable economic loss.
Yes, sir.
And as I said, the recorder had put the cart before the horse in terms of his Type 3 nuisance, and one can see why the Court of Appeal found against him on that and said he got it wrong because that would be pure economic loss, because he was saying the damages constitute the cause of action, and obviously that's the wrong way round. But once there is a cause of action, which is there something capable of amounting to a nuisance, which is what Williams dealt with, and Williams says encroachment of Japanese knotweed rhizomes is capable of amounting to a nuisance because of the immediate burden on the landowner. Then once a defendant is under a duty, breaches that duty, etc., then if you decide to sell and have to sell at an undervalue, that is a consequential recoverable loss. It is not pure economic loss.
Okay. I think we've probably covered your 3 points, and you were then going to come on to the respondent's notice points.
Yes.
Which order do you want to deal with them in?
Okay. I'll deal with ground 1 first, and then ground 2.
So, causation.
The causation point, my lords. I had already conceded at trial that in terms of the cost of treatment, that claim would fail on the but-for test, because so the district judge at trial found that knotweed had encroached before the defendant came under duty, but then the defendant carried on failing to treat until 2018, and so there is a period from 2013 until 2018 where the defendant was in breach, and the respondent's case is, well, makes no difference because you already had knotweed. I conceded that point at trial, and I don't resolve from that concession in terms of treatment costs, because once knotweed is on the land, it has to be treated. The difference is in terms of diminution in value, and really, I say your lordship's decision on this is going to come down to a question of who bears the burden, effectively, of evidentially on this point, because there was no evidence at trial. There was evidence from a valuer about the diminution in value of the land, but there were no Part 35 questions from either party, and the report did not deal with how the diminution would have changed over time. So thinking about it, if there's diminution because there's knotweed present, one can imagine a property that was affected by knotweed 200 years ago is not going to have the same diminution as a property that had knotweed a year ago or 2 years ago. But there was no evidence about that at the trial, and neither party had called evidence about that. But my point on diminution in value is, as I said, I've made the concession about the treatment costs because they would always have been incurred but for the breach. But the diminution in value is different because the defendant continued to breach from 2013 until 2018, and therefore effectively, using the analogy of a clock ticking, the clock didn't start to tick for 5 years longer than it should have done in terms of the claimant being able to treat his own land. So there's no point to claimant treating his land until the defendant treats theirs, because he can pay for treatment, but unless the defendant treats, it just carries on encroaching and undermines and renders his treatment useless.
Where did the knotweed that was on your land come from originally?
It spread from the defendant's land. As to where it had originally come from.
No, well, I mean, did all the knotweed on your land come from the defendant's land?
Yes, there was certainly no finding at trial that it had come from any other third party. It had spread purely from the defendant's land. My case, and my learned friend will of course take the opposite view, but my contention is that it was incumbent on the defendant to put Part 35 questions, or to put into evidence, well, effectively Part 35 questions was the only realistic option, because I don't think it was a joint valuer. To put Part 35 questions, if it wanted to run that causation argument, to say, well, even if we were in breach, what effect would that have had? Because as it stands, there is no evidence about that. There was a report in binary fashion saying this is the residual diminution in value. Now, somebody could have asked the valuer how much would that diminution in value have diminished over how long a period of time. So, for example, would it have gone down by 10% every year over 10 years and reduced to nothing, or 5% per year over 20 years, whatever that might be. Nobody asked, and there was no evidence about that at trial. That's why I say really it turns on a question of who bears the burden. Because your lordships, if you are against me, would say, well, the claimant should have gone to court prepared with that evidence. But I say actually it was incumbent on the defendant, if it wanted to run that argument, to put Part 35 questions to the valuer to say, well, if the court finds we were in breach until 2014, 2015, 2016, what effect would that have had? And there is no evidence about that. So, as I say, I've made the concession all along about treatment costs, but the diminution in value, I say the respondent's causation ground has no teeth because there is no evidence to support what difference it would have made financially. And the starting point.
What evidence? What difference? What would have made?
If the defendant hadn't been in breach, so the defendant was found to have been in breach of duty from 2013 until 2018, so 5 years. So if the defendant had not been in breach and complied with its duty from 2013, rather than waiting 5 years until 2018, the clock would have started ticking sooner on fixing the problem. The claimant could have treated his own land, knowing the defendant was treating their land, and the starting point, I say, is the obvious proposition that at some point the diminution in value is going to go away. Because again, if your lordships were looking at buying a house that had knotweed 200 years ago, that's not going to concern you.
So why doesn't the burden simply lie on you? Why don't you just have to prove the loss?
Well, I say because the evidence was that there was a diminution in value, and it was for the defendant to put into evidence that point about what difference it would have made, rather than the claimant, because it's almost thinking about it in terms of a personal injury case, for example, a Holtby discount type case. So getting into divisible and indivisible injuries now at this point, but thinking about, so for example, in a divisible injuries case, a defendant must plead and prove the extent of either a third party or innocent exposure, whatever it might be, that contributed in terms of causation. So if a claimant suffers some form of personal injury that's a divisible loss, but only 50% of it is caused by the defendant's breach, the burden is on the defendant to plead and prove that 50%. Otherwise, the defendant is liable for the entirety of it. And we are talking about something divisible that happens over a period of time, and therefore the defendant, if it wanted to run that argument, could and should have put questions to the surveyor to ask that effect. And that is why I say the burden is on the defendant rather than the claimant. And my point's really as simple as that, and your lordships will either be with me or against me on that, but it's that simple.
And then the other point in the respondent's notice?
Yes.
The evidence, is that the point?
Yes. Well, again, I have a very short reply to that, which is simply that, and apologies while I just go back to, I'm sorry, my lord, the judgment.
As put by Mr. White, the question is your evidence sufficient to establish the 4,900?
Yes. Well, the judge, in his decision, excuse me again, sorry with the pagination. I'm sorry, my lord, just 1 minute. Thank you. I think so. Which page? Okay, thank you. Yes, thank you. So page 57, using my numbering. Thank you to my learned friend. And it is paragraph 21 of the judgment, which is, as to the respondent's point that the evidence was not sufficient, that the judge was correct.
Sorry, which paragraph?
Paragraph 21. The judge was correct to say that he would have remitted it because it isn't clear enough from the district judge's decision that he made clear findings one way or the other. And
so you're asking us to remit it then?
Well,
if you're saying he's correct to have remitted it, just said he would have remitted it. I thought you weren't asking us to remit it.
Well, my lord,
wasn't trying to be a hostile question, Mr.
No,
Carter. I'm just trying to understand where
it
you're
wasn't,
coming
my
from.
lord. I'm sorry, it wasn't. I didn't interpret it as a hostile question. I'm sorry for taking a moment to respond. I'm actually referring myself back to my own skeleton. I mean, I've said page 31 using my numbering the core bundle. I've only dealt with it very briefly in my skeleton, which is to say that the judge was correct to hold that the district judge did not find the evidence was insufficient. And I've made the point in paragraph 25, Mr. Rain, who was the valuer, gave various figures in his report, and effectively was done as a table with discrete figures, of which 4,900 was residual diminution in value. My primary contention on respondent ground 2 is not to remit, but if your lordships are with me that diminution in value is recoverable, then based on the evidence that was available, I would contend for the figure of the 4,900. The judge in paragraph 21 said had he found it was recoverable, he would have remitted.
Should we look at what the district judge said about this?
Yes. Starts
So I'm on
page 94. 94, thank you.
Which paragraph are you in?
Yes, it is.
It's sort of right about 98, isn't it?
Yes. 101 on my numbering, paragraph 32.
Okay. Let's just. Should we read paragraph 32?
Yes, please. Thank you, my lord.
Yes.
The difficulty, and part of the reason I hesitated so much, and as I say, I hadn't interpreted your lordship's question as hostile, but the judgment of District Judge Fouracre is, no criticism intended, but not particularly detailed on a number of points. His Honour Judge Beard's judgment I commend. The judgment of District Judge Fouracre is not particularly helpful, and he hasn't given, and I have to accept that he hasn't given any obvious figure.
So how do you get round what the judge said about the need to remit?
Yes, well, I think taking stock, I would concede that if you are with me on my ground and you find diminution is recoverable, then I of course object to ground 1 for the reasons I've said in terms of causation. But if you're with me on my ground 1 and with me against respondent's ground 1, then I would have to concede the matter would need to be remitted to the district judge to reconsider.
I mean, to be absolutely candid, Mr. Carter, I understand the submission you've made, but it depresses me when you're talking about a figure, £4,900, which would be a small claim. Yes. The idea that this court should remit it when this case has already been to a second appeal seems, well, as I put it, already depressing. But I understand what you're saying.
Well, I wouldn't argue against that word, my lord. But the difficulty is that there just isn't the decision from the district judge about the value. And so depressing as it might be,
We don't have the it would not be right for us to hazard an estimate on the basis of the information that's available to us.
well, this,
You see, what bothers me is exactly that. Is sorry to cut across you. Is what we have is evidence from your witness that says that the diminution in value is 4,900.
yes,
He also, in his report, added the 1,400 figure, which is the figure that the district judge specifically called out, and he said in particular. So he clearly didn't buy that, and you're not now asking for that. But as I recall, there's no other evidence in the case about what value below 4,900 one should arrive at.
So there'd have to be more evidence.
Well. So one would then, is it really right that there should be more evidence? I mean, the time for evidence is way long past. So what one is left with, if one is in this situation, is somebody coming to a view about what the right number should be based on the material we do have.
yes.
Starting from 4,900 and no doubt going only downwards, one would assume.
Well, the 4,900 figure was specifically for the residual diminution in value post-treatment.
Yeah.
And so that is the figure, and that is why in my skeleton I've contended for that figure. I do ask your lordships to allow that figure, but as I say, I have to accept that the judgment of District Judge Fouracre is not entirely clear on.
So you invite us to adopt a proportionate
Exactly.
approach.
Exactly. I am.
What figures were an issue before Judge Beard? Had you made all the concessions which are now in place, which means the only number that was left was 4,900?
Yes, I conceded treatment costs, and I think it is only the diminution in value figure which remained an issue.
Right. Okay. You?
Right. So we've now got to the end of the submissions, and we now get to the
Yes,
authority.
The Dennis case.
Have we-
your lordship's been handed
No.
up? Oh, sorry.
We should have we got 3 copies, Mr.
My
White?
Lord, I've brought 3 copies. The reason I've not handed them in is because whilst I plan to allude to the case in my submission, I wasn't convinced that you were going to want to see it, but it's adopted rather more importance than perhaps it might otherwise have done. So shall I pass 3 copies up?
Yes, I think we will proceed as I indicated, which will rise now. So Mr. Carter can have a chance to read it, and we can have a chance to read it. How long is it?
30 pages.
30 pages.
30 pages, although this is a... yes, it's not short. It's got a head note, though.
That clock is half an hour slow, by the way, in case anybody's proceeding on that basis. Time hasn't gone that slowly, Mr.
Well, my lord, if I could have, just thinking about lunch being 1 to 2, if my learned friend submissions are this afternoon, if I could have until 1:30, I mean, I'm not going to have 30 minutes of submissions on Dennis, but if I could perhaps have until 12:35.
Should we rise and read it? Yeah, I think so. Yeah, we'll rise and read it.
Thank you.
Lord, would it be helpful for me to give everybody a 2-minute sketch on what it says before you rise, or would you all rather take your own view? Might speed
I think
up.
we'll rise and take our own view, Mr. White. And so it's now, by real time, it's just gone 12:10. We'll come back at 12:30.
Are there any particular paragraphs that either of you want us to focus on?
Yes, that's a good
That
idea.
would be helpful.
I'm afraid not. The reason that I've given it to Mr. Carter is that it is an example of a case in which diminution in value was recovered in nuisance without it being consequent on physical damage to property. And
Whose decision is it?
Mr. Justice Buckley
Right.
in
Which one?
2003.
I said the more recent one. Right. Okay. Well, we'll proceed as I indicated. We'll rise and come back at 12:30. If we can have copies of that bit. Great.
going to pop out to the gents.
to raise?
Right. So, have you had a chance to consider it?
I have, my lord, yes. And I've got a few points to make. It will take me 5 minutes.
Okay.
The first point is looking at paragraph 83.
Yes.
We can see that
The point wasn't argued in terms as a matter of principle, was it?
it doesn't seem to be.
Yes, go on.
Well, under 83, it was clearly there were 3 heads of damage there. The judge then went on to consider them together. Your lordships have obviously read the judgment, you've seen the figures. But firstly, this is clearly an example of the court awarding damages based on financial loss in a nuisance claim. But I have a second point to make, which really flows from my point about the flexibility of the law of negligence and nuisance, and putting Williams to one side, what the law should actually be. And that is this. Davies, my lords, particularly if we look at paragraph 91.
Dennis, I think.
Dennis, sorry, not Davies is this case, Dennis. Paragraph 91 and 92. So in paragraph 91, because damages were awarded for common law nuisance, that was then just satisfaction for the purposes of the Human Rights Act. And paragraph 92 is a summary of, contrary to my view, then there would have been a claim under the articles, which were Articles 8 and Article 1, Protocol 1 of the European Convention on Human Rights. The point is this, my lord, and I would take you please to the authorities bundle, and it's the recorder's decision in Williams at page 53. And it's paragraph 104. In Williams, there was no claim under section 6 and 7 of the Human Rights Act for a breach of Article 1, Protocol 1. It hadn't been pleaded. But there was reference in that case to Thomas and others against Bridgend County Borough Council, which is authority that Article 1, Protocol 1 expressly does exist to protect economic interests. And that is also clear from the Dennis case, which is summarised, as I say, in paragraph 92, where Mr. Justice Buckley said he would have awarded damages under Articles 8 and Article 1, Protocol 1. But my point about the development of the law, if you putting Williams to one side, is the irony of the respondent's whole argument is the respondent is a public authority. So if your lordships find that in nuisance a claimant shouldn't be able to recover damages for diminution in value, then a claimant can bring a claim against this defendant or any other local authority under section 6 and 7 of the Human Rights Act and say you have breached Article 1, Protocol 1, which expressly does provide for the protection of economic interests. Network Rail, and I don't have the authority off the top of my head, but there is authority from, I think, the rail track disaster in the 90s. There was a claim under the Human Rights Act against
It's a public
or
authority.
predecessor.
It's a public authority.
It isn't.
It isn't.
No. There was an argument in a case, and I can find the reference if your lordships want one over lunch, but there is certainly authority that
And
network.
this is quite a long way from where we are in this.
Well, my point is this: the only people who would benefit if you are with my learned friend and against me on this point is not actually the defendant or any public authority. It's Network Rail, who never argued this point in the Court of Appeal. And if your lordships were to find that either Williams is authority that, or that simply on its own back, damages for diminution in value are not recoverable in nuisance, then claimant could bring a claim against the local authority for a breach of Article 1, Protocol 1.
Okay, just taking us back to what this case is
Yes.
about. If and what happened in Dennis was that the issue, the principle wasn't, as far as we can see, first reading wasn't discussed, and the judge adopted what looks to me, for my part, to be a fairly broad brush approach to the assessment of what the damage, the loss of capital value would have been.
Yes.
The figures there are much greater in this case. He looked at the possibility of sale,
Yes.
notwithstanding the fact that the claimant in that case had said he didn't wish to sell and no intention of selling.
Yes.
And that the value would be fully restored within, whatever it was, 10 years
Yes.
of the hearing.
Yes.
On those facts, the judge awarded damages, but significantly reduced a fraction of what was he found to be the loss.
Yes.
So, what guidance does that give us? Any guidance as to the proper approach? 2 points. First of all, the question of whether we should remit, and secondly, how we should approach, if we get this far, how we should approach the calculation of damage of damages.
Well, on the question of remitting, the fact the judge took a broad brush approach in this case, in the Dennis case, is, and it's trying to say, of course, that the court can take a broad brush approach if appropriate, militates in favour of not remitting and taking a more proportionate approach. The significant reduction, however, if your lordships don't remit, I contend for the figure of the 4,900. That was a clearly discrete figure for the stigma of having had knotweed even after it has been treated. That was a discrete, distinct figure in the expert's valuation. But it militates against remitting in terms of proportionality, and your lordships could, of course, take a broad brush approach.
If, as I understand, Dennis, what the judge did was to say, what is the diminution in value, of capital value,
Yes.
of the estates now? And he was told that the figure, I think the figure was something like £4 million, I think.
Yes.
He said, at paragraph 83, the paragraph you referred us to, Mr. Dennis says he doesn't want to sell, but he might be forced to
Yes.
in the years until 2012, which is when they're going to stop flying jump jets out of RAF Wittering.
Yes.
And so there's a chance he might need to sell,
Yes.
or reasonably want to sell in the next 9 years, I think it was, from the trial. And I assess that as between 5 and 10%. So £300,000 is the loss in capital value. Rough, broad
Yes.
brush. There's a chance he might wish to sell. So it's a 5 to 10% of 4,300,000.
Well,
That's what he did.
yes.
He also then assessed loss of amenity, because there the noise was going to continue. So there was a continuing
Yes.
loss of amenity, and also there had been loss of amenity since 1984.
Yeah.
Okay, so just concentrating for a second on the loss of capital value. Your £4,900, as I understand your expert evidence, was the sum as and when at the time at which the treatment was complete, the residual
Yeah, exactly. Yes.
blight, what I think Lord Justice what Mr. Justice Buckley called the blight.
Yes.
Right. So that's your top end, isn't it? If your client was effectively forced to sell immediately.
Yes, and that goes then to my response to the respondent's ground one about causation and about who should have, if they wanted to raise it, put that in evidence to the expert about what difference would that 5-year breach of duty period have made. So that goes to that question, I would say. But in Williams at trial and in the Court of Appeal, at trial there was no finding of fact that the claimant did intend to sell, and in the Court of Appeal there is nothing in the judgment in Williams about, there is talk of an immediate burden on the landowner, but there was, again, diminution in value was not challenged in principle by Network Rail, but again, there was no challenge on that appeal, even on quantum, based on whether or not the claimant actually intended to sell. So there is a presumption, I would say, that £4,900 is the starting point. And if the defendant wants to rebut that presumption, it can do so with questions, but it is a rebuttable presumption that is the starting point. There is no need, certainly reading Williams, for a claimant to actually have an expressed desire to sell, or in the alternative to say.
Okay, but in this case, the district judge did not resolve this, did he? There aren't any findings.
No.
So it's
it wasn't.
It's got to be adjudicated on, hasn't it? Your argument is I'm entitled. It should be 4,900.
Yes.
Well, let's see where we are after we've heard Mr. White. One option would be for us to invite some written submissions on this, but let's see where we are with Mr. White.
Noted, my lord. One point, if I may, and I realise I've started making this point, and your lordship has picked up on not wanting to move too far away from the case, and I'm conscious of that. But it will take me 2 minutes, and I do want to emphasise this point because I genuinely think it is relevant and important.
Okay.
The point I've made about the irony of the case, and about Article 1, Protocol 1, and about the development of the law, where that would leave the law is if your lordships find diminution in value is not recoverable in nuisance, in a case for knotweed, then the reality is a claimant would be bringing small claims only, because the cost of herbicide treatment is a couple of £1,000. There might be at most a few £1,000s claim for general damages for distress and inconvenience. So against somebody who isn't a public authority, like Network Rail, claimants would be left with, unless they've got deep pockets, no remedy, because they can't recover their legal costs, therefore they wouldn't be able to have lawyers acting for them on conditional fee agreements. If they did pay privately, they wouldn't recover their costs. Whereas against this defendant or any other local authority, the claimant could bring a claim under Section 6 and 7 of the Human Rights Act and say you breached Article 1, Protocol 1. That would put them above the
6 and 7.
Section 6.
Section
6 is the obligation on the local authorities to comply.
Yes, that's fine. Sorry, I thought I was thinking article. You mean
no, sorry, my lord. Yes.
You mean article?
It would be Article 1, Protocol 1, A1P1 of the Convention.
Okay.
But within the Human Rights Act, Section 6 is
fine. I follow. Sorry, my mistake.
No, that's fine, my lord.
But what the measure of damages in such circumstances?
Well, they would. My point is, in terms of the development of the law, it would mean that a claimant who has knotweed encroaching from a local authority could bring a claim under Article 1, Protocol 1 of the Convention, under Section 6 and 7 of the Human Rights Act.
Yeah.
And because that expressly provides for protection of economic interests, their claim would be worth more than £10,000. Therefore, they can recover their legal costs, whether it's a fast track or multi-track claim. But against Network Rail, who there is authority is not a public authority, they could not bring such a claim. Therefore, they would be looking at a small claim, and so either they would.
Sorry, this is just a consequence of the fact that public authorities can be liable for breach of human rights obligations because they owe them. I mean, that's the law.
Of course, it's the law, and it's the reason, my lord, that I'd highlighted that paragraph in the recorder's judgment, and then I hadn't referred to it in my submissions because I'd hesitated about whether or not, because I could foresee the point about getting too far away.
It's a
from the
separate
facts
cause
of
of
this
action.
case.
There exists a separate cause of action against public authorities.
Yes, but surely the law, the common law, negligence or nuisance, should recognise that that puts a claimant who is unlucky enough to have knotweed spread from X's land as opposed to Y being a local authority, in an impossible situation. And I say that is a relevant point to the common law and the development of the law. So that's my point.
Okay.
Thank you, Mother.
Thank you. Anything else you want to say on Davies?
No, thank you.
Thank you very much, Mr. Carter. Mr. White. So it's now 10 to 1. Remind you that's 20. half an hour behind. Yes?
My lords, the broad unifying principle in this area of law is reasonableness between neighbours. If that phrase sounds familiar, it's because I've poached it wholesale from paragraph 45 of Williams. It will become something of a theme in what I say. It is necessary for you to have some eye on the facts as we look through what is reasonable and otherwise between neighbours. Unfortunately, we're in the happy position where there are no disputed facts. But nonetheless, I begin by taking a few minutes to highlight some facts, and then I propose to take the three issues in the same order that Mr. Carter has, dealing with diminution, then causation, then. It's common ground the claimant purchased in 2004, and it's common ground that by that stage the property had been affected by knotweed for many years. For your notes, page 187, there, Mr. Gregson. That knotweed probably reached the defendant's land by being thrown over the garden wall from either the claimant's garden or one of his neighbour's gardens. I take that from paragraph 3.2.7 of Mr. Gregson on my page 191. I'm conscious that we might have parted company slightly in terms of page numbers, and so I'll give you the paragraph reference as well.
Sorry, Mr. Greg.
This is the single joint expert.
That's the single joint knotweed expert.
Sorry, I'm just looking for the. Sorry, can you give me the reference again?
Yes, paragraph 3.2.7.
Do you want us to look at that?
No, there's no need. It simply says that the knotweed probably got onto the defendant's land by being dumped over one of the garden walls. And what's happened then is that the defendant wasn't sufficiently assiduous as to notice someone's dumped knotweed onto my land. And from there it spread, or spread back, onto the claimant's land long before 2004.
Well, sorry, wait a minute. 3.3.7 doesn't say it came from the claimant's land at the start.
No, claimant or one of his neighbours. It was dumped over one of the garden walls.
Doesn't say that either. It says over a garden wall many years ago.
Yes.
Right.
Well, that.
I'm not.
I think that's. I think it was unfortunate that you allowed us to form the impression that it formed any part of this report that it might have been the claimant's. I don't think. I'm sure.
No.
I'm sure that wasn't the intention.
Claimant's garden or one of his neighbours, and without question, not the claimant, because he didn't live there then. So there's no. I don't mean to imply at all that the claimant is the one.
So somebody dumped it on the land. Okay.
Dumped it onto the defendant's land. The defendant didn't spot that had happened, and it spread or spread back to the claimant's land.
Well, it's the spread back bit. It's when you say spread back, I think speaking for myself, cause us to rise again, because that means you were saying it came from the claimant in the first
We
place.
don't know.
Well, in which case, don't say it came back then.
It must have come from somewhere. Somebody must have gone on your client's land somewhere.
Yes.
Somehow.
one or
Somebody
other.
brought it on.
Doesn't matter which one.
And,
Right.
okay, all right. Fine. We'll delete the word back from our notes.
Yeah.
Doesn't add anything to your case.
No, it doesn't.
Right.
Right.
But
Okay.
what the defendant then fails to do is notice that it's happened, and so it spreads to the claimant's garden.
Yeah.
Long before 2004, when he buys the property. So he buys a property that's affected by knotweed, and there it stays. In the meantime, the claimant rents out his property. He doesn't live there. It's an investment, held as an investment, effectively. The defendant, however, should have spotted the problem and done something about it in 2013 through to 2018. That's the period when it was in breach of duty. Started to do something about it in 2018, and from that point it wasn't in breach anymore.
But isn't it implicit in the breach of duty finding that there wasn't knotweed on the claimant's land during this period? I mean, if there'd been knotweed on the claimant's land throughout this period, why was there a relevant breach of duty by your client? I thought it's implicit that the rhizomes on the land, the claimant's land, came from the defendant's land.
It is, and it's accepted that the rhizomes on the claimant's land came from the defendant's land, but they came from the defendant's land long before breach. That's my point. And I take that, if you need to find it, it's at paragraph 3.1.11 of Mr. Gregson's evidence, which is on my page 187.
By the breach, I mean the encroachment element of the nuisance
Yes.
was at an unknown earlier date.
Correct.
But the breach, in other words, looking at what the Master Rules said in Williams, whatever paragraph it was, 56, was it? The point at which you had actual knowledge or ought to be aware of the risk. That's the point where the breach arose.
Sorry, I'm looking at 3.1.10, 3.1.9, 3.1.10. That's 10 Dynam Street is the relevant property, is the claimant's property, yes?
Yes.
So what it says is, behind 10 Dynam Street and several of its neighbours is a long-established stand of Japanese knotweed, i.e. on your land, on your client's land. The claimant states he's been aware of it, i.e. the long-established stand of Japanese knotweed on your client's land since he bought 10 Dynam Street in 2004. I do not doubt it was present for many years before then. He's not saying the claimant was aware of Japanese knotweed on the claimant's land when he bought it. I mean, that's saying that he's been aware of it, i.e. the long-established stand on your land since before he bought 10 Dynam Street.
Yes, can I just have a moment to dive under the bench and pull something from my bag?
Well, do you want to come back to this point? We're nearly at 1 o'clock. Do you want to come back to this point when you've had a chance to think about that? That is what it says, isn't it?
Very well, it is what it says, yes.
Right.
Well, I'm happy to pick up there at...
Well, what do you want to get out of your bag?
well, it's the claimant's statement, because what Mr. Gregson is doing is quoting the claimant's witness statement, where he refers to having seen Japanese knotweed in 2004. I'm reminding myself of exactly what it is that he said he saw in 2004.
Well, does the judgment, either of the judgments help with that?
The first instance judgment
Page 97 of my numbering, paragraph 13 of the judgment. Thank you.
yes, that covers the point.
Which paragraph?
13.
1-3, sorry. Oh, you've got a different page.
I'm just not sure I can make sense of that, to be perfectly honest.
Well, after lunch, I'll take you to the relevant sections of the evidence. But
Okay.
put simply,
The encroachment in 13, that means the encroachment onto the claimant's land, does it?
correct.
Yes.
Having been dumped over the wall of the neighbouring property onto the defendant's land.
But it doesn't say that it had been dumped over by the predecessor entitled to the claim.
No, it doesn't matter though. My point is, it came from a garden. I don't care who's gardening.
Okay, but so I'm struggling to know where we're going with all this.
Well, I think as it is about 1 o'clock, you obviously want to take a step back and present your case on this by reference to another document. We'll let you do that at 2 o'clock.
I'm grateful, Mum.
Thank you, Mr. White.